All right, good morning once again, students of the Western Pacific University, taking the course of Economic Law. The last two lectures have covered the essential elements of contract. Like I said, it's a huge content trying to cover the law of contracts. I'm just going to highlight you the basics of what the law of contract is. So what we did was we looked at the essential elements in forming a contract. We look at what is offer, acceptance, consideration, and the meeting of the minds, the intention to create a legal relationship. All right. Before that, we looked at offer and acceptance, and after that, we looked at consideration and intention to create legal relations. All right. Now I'm going to look at the other end of the spectrum, which is take you through what happens when there's a breach of contract and how can a contract be breached. That's basically what I'm going to take you through right now. All right, so if you look at your slide, slide number 3, I will upload your slides. It says that a validly formed contract can be terminated or discharged in a variety of ways. 1, by mutual performance of the contract itself, automatically discharged, no residual liability. So mutual performance, like I said, so we contracted for me to sell my Toyota 5-door for 100,000 kina. If the buyer comes, give me 100,000 kina, and I hand over the 5-door and transfer the registration of the vehicle over or under his name, we have discharged the contract by mutual performance, performing the contract or by both sides of the parties to the contract. All right. Secondly, by consent or at will. What is created by consent can be undone. In the same way, formality or consideration is usually required. So, for instance, in this case, like we would say that we agreed to enter into a contract, and then we said that we are going to settle the contract tomorrow. But tonight, I just looked at the car and said that, I felt like I didn't want to sell my car, and he sort of like checked his finance, and he was like, yeah, I'm not willing to part ways with 100,000 kina. So the buyer calls me and I said, let's end the contract by consent or by will. So we both agreed to sort of do away with the contract. All right. The third way is by failure of a contingent condition. If you look at it, for breach of contract, repudiation delay depends on the individual action of the party, right to sue for damages and survive termination by operation of law as a result of frustrating event. All right, so when you look at when you say that for breach of contract, repudiation and delay, so that means that if you breach a contract, that means that the contract is terminated, or if you repudiate the contract is terminated, or if a delay happens, basically it will bring the contract to termination. The last one you see is by operation of the law as a result of a frustrating event. This means that it is automatic, no residual liability if nothing is unconditionally accrued before termination. So, for instance, by operation of the law, like we say that I want to make a contract with a government department. So, under the Public Finance Management Act, the head of department is entitled to sort of make contracts under or for the sum of 50,000 kina. And then when we're making the contract, and then we realize that, the contract is worth 100,000 kina. By operation of the law, which is the Public Finance Management Act, that contract cannot be effected. So the law would sort of frustrate the contract. So this is like the ways in which a contract can be brought to an end. All right, let's look at termination for breach, repudiation, and delay. Termination of breach. If you look at lecture slide number 6, it says that strict liability for breach, fault generally irrelevant. All breaches give right to claim in damages, even nominal. Right to terminate will depend on the classification of the term breached. Condition, entitled to terminate. Warranty, not entitled to terminate. Intermediate or nominate, depends on the gravity and the consequences of the breach. So when you're about to breach for a contract to terminate, we look at there are 3 types of terms in a contract. The first term is a contract, is a condition. That means that the condition is a fundamental term of the contract, and it goes right through the heart of the contract. If you breach a condition, the contract will terminate. But warranty, the contract is not entitled to terminate, and intermediate or innominate term depends on the gravity of the consequence of the breach. So, conditions entitled to terminate. Conditions, for instance, if I'm selling my car, and if you don't pay me 100,000 kina, that's a condition of the contract. It's a fundamental term of the contract. So if you get my car and you don't pay me 100,000 kina, there's a breach of a condition which goes right to the heart of the contract, and the contract terminates. While warranty is where the contract is not entitled to be terminated. So warranty might be, I said that bring the car, we exchange the car and the money at 2 p.m. and you show up at like 2:01. So like it's the timing, sort of like it's an important term, but it does not have the effect of terminating the contract. And intermediate or innominate term, it depends on the gravity and the consequences of the breach. So remember, if you breach a condition, contract is entitled to terminate. Warranty, you're not entitled to terminate the contract. And intermediate depends on the gravity and the consequences of the breach. Alright, warranty. So warranty, what we're talking about, warranty is a promise that is not an essential term. Breach gives rise to right to claim damages, but not right to terminate the contract. Condition. Promise that is a major or essential term, like I said, goes out of the contract, give rise to a right to affirm contract and claim damages, or terminate contract and claim damages. So when you breach a condition, it is affirm contract and claim damages. So for instance, if I sell you my car, you failed to give me 100,000 kina, I can affirm the contract and say that there's a breach of contract, and I am entitled to damages, the sum of 100,000 kina plus stress and suffering and all these extra damages on top. Or I can say that I can seek terminate the contract and claim damages. So I can say that no, the contract has come to an end, you have breached the contract terminates, you now have to pay me 100,000 kina. When I say affirm the contract, it means that I'll say that yes, there's a breach, there's a valid binding contract there, and I will ask the court for them to compel you to perform the contract. So I'm affirming the contract, and the courts will compel you or specific performance for you to perform the contract and give me 100,000 kina. Or I can terminate the contract and say that no, there's a breach of a condition, the contract terminates, and I'll claim damages against you for breach of contract. I hope that's clear. Alright, test of essentiality. Whether it appears from the general nature of the contract, which is all, or from some particular terms, the promise is such of importance for the promisee that he would not have entered into the contract unless he had assured a strict or certain performance of the promise, and that is ought to be apparent to the promiser. That means that it's sort of the test of essentiality is talking about when you look at the contract, it is sort of the person that undertakes the contract, they have basically been assured that the contract will be performed. That is why they got into the contract in negotiating with the other party. So when you look at the essential of the term, it comes from the contract itself, and basically it depends on the judgment and enrichment of the general nature of the contract and its particular provisions. There is close account of the importance of the parties advantage the provisions evidenced by contract itself is applied to the surrounding circumstances. So it looks at the terms of the contract and say that no, parties are clear. Parties are in a way sort of wanting to be bound by the terms of the contract. So there must be an essentiality of terms. Alright, so we give you the case example of Luna Parkway versus Tramways Advertising. There was a contract between the two parties there. That's slide number 8. And basically, Luna Parkway was saying that we guarantee that these boards will be on track at least 8 hours per day throughout our season. Luna Park notified and terminated. Trams Advertising kept advertising and sued for contract price. LP cross claim for damages for breach of contract. So that's basically a case where one party agreed that for 8 hours they would per day the tracks will be used by the trams. However, they failed to deliver on that, and as a result they were sued for damages for breach of contract. All right, and then also you look at some positions about